I appear with Mr. Swanya, George Sekimpa, and Tom Macharia for the Deputy President of the Republic of Kenya in the consolidated petition and in any other petition where he is a party. Thank you.
My name is Khamino. I appear for Kituo Sheria. As interested party in E565 of 2024 with my learned friend, Mr. John Maridi. I haven't seen him at the John Maridi, advocate. That I took Kituo Sheria. And then I also appear for myself. Do you understand? That's it.
Good afternoon, my lady and my lords. For the third petition, my name is Moody.
May it please you, my lady and my lords, my name is Nelson Harvey. I appear for the University Party of the Law Society of Kenya, together with my two colleagues, Jose Manua.
Where are they? Is that Jose and who?
Jose Manua and Kevin Michuki.
Where's Kevin?
Behind the cameras.
Maybe perhaps for guidance on which matters we are taking for a month. Because this afternoon, and I believe my friend will address it, we were served with the notice from the office of the deputy registrar indicating that there were several matters that were mentioned before you this morning, this afternoon. And last evening when we were breaking, we were to come for a ruling. Perhaps we need to have clarity that we not have a mixture of things.
We are dealing with the ruling matter in which the ruling is supposed to be delivered now. After that, we'll give directions.
Then if that is therefore, then it means there's some advocates of God on record for forum who participate or are not participating.
Like who?
Like Nelson Harvey. But
Lord, then we have asked them when they will spend some little time with this movie. God doesn't agree to that. There's no harm in that I am appearing on record.
yes, is there any other concern before we read the ruling? Our ruling is ready on the consolidated petitions, with the lead file being petition number E565. We have set out the structure of the ruling, but we'll begin from our analysis of the issues that we think are relevant for now. This is the ruling. Having carefully considered readings, submissions, and evidence on record, we consider the following issues arising for determination. One, what are the prevailing constitutional and statutory interpretation methods? Two, whether the Honorable the DCA can assign judges pursuant to Article 165, Sub-Article 4 of the Constitution. Three, are there related. On the first issue, the Constitution is a document sui generis. It is the ground norm which legally commands superiority and dominance over other laws, and its interpretation, as of necessity, must be in a manner that all other as capture centrality of the Constitution as follows. The Constitution of a nation is not simply a statute which mechanically defines the structure of government and the relationship between the government and the governed. It is a mirror reflecting the national soul, the identification of ideals and aspirations of a nation, the articulation of the values in its people and disciplining its government, the spirit and tenor of the side and permeate the process of judicial interpretation. Before the court, the High Court has once again called upon to address the issue as to whether the Honorable the Deputy Chief Justice of the Republic of Kenya, whom we refer to herein as the DCJ, can exercise the power of assigning and empaneling expanded benches of the High Court. As such, the interlink between Articles 161 sub-Article 2 and Article 163 sub-Article 1 and Article 165 sub-Article 4 of the Constitution, as well as Section 5 of the Judicial Service Act, come into play. On that score, it is paramount to briefly look at how the Constitution and the statutes ought to be interpreted. As a starting point, the Constitution itself provides for its own theory of interpretation. That is in Article 20, sub-Article 4, and Article 259, sub-Article 1. Article 20, sub-Article 4 requires courts, while interpreting the Bill of Rights, to promote the values that underlie an open and democratic society based on human dignity, equality, equity, and freedom, and the spirit, purport, and the objects of the Bill of Rights. Article 259, sub-Article 1 commands courts to interpret the Constitution in a manner that promotes its purposes, values, principles, advances, and rule of law, human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. In hailing the Constitution of Kenya as a highly transformative one, courts have over time developed various methods or canons of interpretation. In the case of David D. and others versus Attorney General, the learned High Court judges dealt with four constitutional interpretive principles, being that the Constitution must be interpreted holistically, that the Constitution does not favor formalistic approaches to its interpretation, and it must not be interpreted as one would a mere statute. The Constitution has provided its own theory of interpretation to protect and preserve its values, objects, and purposes, and that in interpreting the Constitution, non-legal considerations are important to give its true meaning and values. The Supreme Court, in the matter of the Kenya National Commission on Human Rights, Supreme Court advisory opinion reference which I've given at paragraph 26 answered the question as to what holistic interpretation of the Constitution means. The court stated as follows: what is meant by holistic interpretation of the Constitution? It must mean interpreting the Constitution in context. It is contextual analysis of a constitutional provision, reading it alongside of what the Constitution must be taken to mean in the light of the history of the issues in dispute and of the prevailing circumstances. In the case of Tiny Fuza versus Attorney General, which I've given, citation I've given, the court was of the firm position that the Constitution must be read as an integrated whole. The court observed as follows: the entire Constitution has to be read as an integrated whole, and no one particular provision destroying the other, but each sustaining the other. This is the rule of harmony, the rule of completeness and exhaustiveness, and the rule of paramountcy of the written Constitution. On the tenet that the Constitution does not favor formalistic approaches to its interpretation, and that it must not be interpreted as one would a mere statute, the Supreme Court pronounced itself in the case in Interim Independent Electoral Commission. The court said as follows: the rules of constitutional interpretation do not favor formalistic or positivistic approaches. The Constitution has incorporated non-legal considerations which we must take into account in exercising our jurisdiction. The Constitution has a most modern Bill of Rights that envisions a human rights-based and social justice-oriented state and society. The values and principles articulated in the preamble, in Article 10, in Chapter 6, and in various provisions reflect historical, economic, social, cultural, and political realities and aspirations that are critical in building a robust, patriotic, and indigenous jurisprudence for Kenya. Article 159, sub-article 1 states that judicial authority is derived from the people. That authority must be reflected in the decisions made by the courts. Close quote. In expounding the principle that the Constitution has provided its own theory of interpretation to protect and preserve its values, objects, and purposes, the retired Chief Justice, His Lordship Honorable Mutunga, had the following to say in his concurring opinion in the Speaker of the Senate and another versus Attorney General. The Honorable Chief Justice then had this to say: in both my respective dissenting and concurring opinions in the matter of principle of gender representation in the National Assembly and Senate, I argued that both the Constitution 2010 and the Supreme Court Act 2011 both provide comprehensive interpretive frameworks upon which fundamental hooks, pillars, and solid foundations for the interpretation of our Constitution shall be based. In both opinions, I provided the interpretive coordinates that should guide our jurisprudential journey as we identify the core provisions of our Constitution, understand its content, and determine its intended effect. He proceeded to say more, which I have included, but I will not read. The Supreme Court also expounded the incorporation of non-legal considerations and their importance in constitutional interpretation. In the case Communications Commission of Kenya and 5 others versus Rural Media Services, at paragraph 356, the court said this: we revisit once again the critical theory of constitutional interpretation and relate it to the emerging human rights jurisprudence based on Chapter 4, the Bill of Rights of our Constitution. The fundamental right in question in this case is the freedom and the independence of the media. We have taken this opportunity to illustrate how historical, economic, social, cultural, and political content is fundamentally critical in discerning the various provisions of the Constitution that pronounce on its theory of interpretation. A brief narrative of the historical, economic, social, cultural, and political backgrounds to Articles 4, Sub-Article 2, Article 33, Article 34, and Article 35 of the Constitution has been given above in paragraphs 145 and 146. We begin with the concurring opinion of the CJ and the President in Gitirau Munya case, where there was reference to Black Law Dictionary, where it was said that references to Black Law Dictionary will not, therefore, always be enough, and references to foreign cases will have to take into account these peculiar Kenyan needs and context. It is possible to set out the ingredients of the theory of the interpretation of the Constitution The theory is derived from the constitution through conceptions that my dissenting and concurring opinions have signaled as examples of interpretive coordinates.